Hello, ladies and gentlemen. I have a very special video for you today. We're going to be critiquing Chris Hauser. I don't know if you guys remember back in the 1.0 course, talking about Chris Hauser. He's a guy who I learned a lot from at the very beginning of my journey. And he was really part of all of my original learning and all of my original work and stuff like that. I don't really have his stuff anymore because I don't think the 1099A is a negotiable instrument. I'm factually, I know it's not. So and then there's some other things that he talks about that I'm not really into anymore, but I'll be covering that in this show as we kind of go forward, because he talks about some of that stuff in the at the beginning of this. What I want to do is I wanted to do like a critique video or whatnot on this presentation and show you guys kind of what I think about it and that kind of thing. I thought about doing a text post about it, but then I was like, it's just way too much. It'll be easier and you guys will enjoy it more if I do a whole video on it. So first and foremost, I'd like to see more of these. If there can be people who can post things up, and myself or anybody else or other gurus or whoever can go around and critique it and look it over and do videos on it. I think that'd be super fun if we had more content like that in this space. So I think it's super cool, and I wish we'd see more of it, and I think it'd be something amazing if we did see more of it. So if there is any interest in me critiquing anyone else's work, let me know, either in the comments or directly message me, and you never know, I might do more of these, because we need to see more and more and more of this stuff, and we need to see more and more people talking about it, because that's kind of where we're headed, right? So first and foremost, this thing that he's doing here, it's some kind of post-criminal relief, some kind of a motion for relief that I don't really know. I tried to dig through some of it as best I could. I'm going to be putting links to a lot of stuff down in the description for the video because there's a whole bunch of stuff. I found this. This is some kind of an appeal. I think this is a criminal appeal from his original case. We're going to go through this a little bit. And then I found this, which this appears to be the appeal docket for what we're looking at now. This is the appeal for his original criminal case. This is the appeal for some sort of relief lawsuit or something that he filed to try to get paid regarding some things that were incorrect about his criminal situation, right? And you can see here on the Tennessee court's website, this is the posted video as well on YouTube, which we're watching over here. So first and foremost, for those that are unaware, I wanted to kind of go through his original situation. I think this appeal kind of covers it really well, right? So back in whenever it was, there was a 302 count indictment by the Davidson County grand jury for multiple counts of forgery and fraudulently filing a lien for their role in filing a total of 102 liens against 42 different individuals with the Office of the Tennessee Secretary of State. Defendant Cooper, was also, prior to trial, defendant Hauser filed a motion to dismiss for improper venue. Defendants Cromwell and Cooper joined in the motion. The trial court determined the motion after a hearing. They determined that venue was okay, blah, blah, blah. Anyways. So continuing on January 30th, 2017, the Davidson County grand jury returned a multi-count indictment containing 302 counts that named 8 defendants. And then here's the list. And you see Christopher Allen Hauser right here. All of the odd-numbered counts of the indictment charged an individual defendant with 1 count of fraudulent filing of a lien in violation of Tennessee Code, a noted section. We should look at this actually really quick now that I think about it. Let's take a look at this. Fraudulent liens. It is an offense for any person to knowingly prepare, sign, or file any lien or other document with the intent to encumber any real or personal property when such person has no reasonable basis or any legal cause to place such a lien or encumbrance or on such real or personal property. As used in the subsection A, person includes any individual or entity. Of course, right? So upon conviction for an offense, make sure I'm with you guys. Upon conviction for an offense pursuant to this section, any court having or exercising circuit court jurisdiction may order the removal from any record the lien or document evidencing an encumbrance. Okay. This section shall not apply to a licensed attorney who prepares a document in the course of representation of a client. That's interesting. A financial institution regulated by the Tennessee Department of Financial Institutions, the Federal Reserve Board, the Office of the Comptroller of the Currency, the Farm Credit Administration, or the National Credit Union Association, qualified commercial financing entity, or an employee or agent of any of those entities who prepares, signs, or files a lien or other document. Okay. A title insurance company or agent who prepares, signs, or files a lien in the ordinary course of business, or a real estate licensee operating in compliance with the Tennessee Real Estate Broker License Act. It's a Class E felony. Okay. This appears to be the one that they were referring to in Mr. Hauser's case. So, and then we have another one here. Charged forgery in violation of Tennessee Code. This is different. Let's take a look at this one. Forgery. A person who commits an offense who forges a writing with intent to defraud or harm another. Okay. Forge means alter, make, complete, execute, or authenticate any writing so that it purports to be the act of another who did not authorize the act, have been executed at a time or place in a numbered sequence other than the fact or case, be a copy of the original where no such original existed, make false entries in books or records, issue, transfer, register the transfer of, pass, or establish underwriting. Okay. Interesting. So each count of the indictment referred to, let's see here, someone else. All accounts in both cases were based on the electronic filing of Uniform Commercial Code UCC financing statements with the Tennessee Secretary of State's office in Nashville against various individuals. Okay. Prior to trial, defendant Hauser filed a motion for change of venue. In the motion, okay, they didn't go with that. Let's see here. Proof at trial. At trial, approximately 30 witnesses testified on behalf of the state. The testimony of the various witnesses revealed that between September 2015 and October 2016, defendants electronically filed a total of 102 liens against 42 different individuals with the Tennessee Secretary of State's office in Nashville, Tennessee. Each lien claimed a possessory amount of either $4, $6, $8, or $12 million in, quote, the money of account or in lieu of the money of account in Federal Reserve notes or a bank draft of the United States dollars or whatever currency is prescribed as lawful currency of all debts, public or private, in the country in which this claim executed. In order to explain the documents at issue, Nathan Burton, the Director of Business Services at the Tennessee Secretary of State's office in Nashville, testified for the state. In his role, Mr. Burton was in charge of staff that files, quote, documents related to business formations as well as UCC lien filings and various other business document filings, end quote. He described a UCC lien filing as, quote, a document that lets when a company, typically a financial institution, loans money to a business, or if there is a person that may be an individual that loans money to another individual for a business transaction, they file something called a Uniform Commercial Code financing statement. What that statement does is it puts the world on notice that they have an interest in whatever type of collateral that was used to make that loan. This isn't actually a bad definition, shockingly. I'm surprised anyone over there knows what any of this is. It's not a bad, it doesn't necessarily need to, let's take a look at UCC 1 financing statement form, right? I know I've covered this before with you guys, but we'll go ahead and just do it again, right? We can go to my website and go to my About page, and we can scroll down and we can take a look at the one that I made. It's been a long time since I looked at it. Let's take a look here. So this is the one that I made back, I don't remember when. It's been a while. 6/15/24, right? So we have, this is for California, right? We have the submitter information. I don't know why that's not there. We have the debtor name, secured party name, mailing address, indicate how documentation of collateral is provided, entered as text, description. Some of it's kind of funny. It's like everything I own, basically, right? Indicate if collateral is held in trust or to be administered by a decedent, so it's held in trust. Select an alternative financing statement. So you can see it's really simple. You can go in here for $5, type in your information, type in the debtor, type in the secured party, type in description, blue, 1990, 2020 Corvette ZR1, VIN number, blah, 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 blah. Now, it says a lot of places that you're supposed to put the value of what it is. Value can change, so you can put like today's value approximately blah. I didn't even do that. I just put in objects and things and all sorts of different stuff because collateral, it just didn't make sense to me that I would put a value in. I didn't quite understand that part at the time. It's been a long time, obviously. It's been a year and a half since I filed this, right? But you can see how simple it is to file one of these. It takes about 5 minutes, and it's about $5, right? So I'm assuming this is true, what they're saying here. If it is true, then they filed 102 of these things, right? So it's a document that basically there already was this debt, there already was this security interest, and it puts the world on notice that they have this interest in whatever type of collateral that was used to make the loan, right? So people get really confused on this, and they think that UCC1 is the lien, right? It's not really the lien, because if we go into Black's Law and we look up the definition of lien, a charge or security or encumbrance upon property, right? A claim or charge on property for payment of some debt, obligation, or duty. Now, this is important, too, because they say here in the definition, when a company loans money to a business, typically, that's all horseshit. All of that whole first section is complete horseshit, all of this, right? Because the thing is that anyone, you could have a tractor that you loaned someone. You could have work that you did for someone that you never got paid. It's any obligation or duty. Let's say you worked and you never got paid. you could file a UCC 1 on that. Let's say, there's many more different reasons why you would use security interest and then let the world know via a UCC 1 above and beyond loaning someone just money, right? That's not the only reason why you do it, right? So, let's take a look at more of these definitions here. We have hold or claim which one person has upon the property of another for some debt or charge. We have obligation, tie, duty, or claim annexed to or attaching upon property by the common law, equity, contract, or statute without satisfying such property cannot be lawfully demanded by another. Pledging the assets available to pay the corporate liabilities. Qualified right of property which a creditor has in or over specific property of his debtor as security for the debt or charge or for performance of some act. See? It's not just financial in nature, right? And that's another reason why we've covered a lot in the course and stuff like that. The word payment and performance mean the same thing. You're seeing that again here, right? Payment might be to perform, right? Very important. Right or claim against some interest in property created by law as an incident of contract. So there's two ways that you would have a lien or a security interest, not the UCC 1, but the one that comes before it, the original actual interest, right? You would have by contract or by law. And you'll see Chris talk about this in the video we're going to cover here in a moment. So by contract has to have all the elements of a contract, right? And then by law would be like a judgment or something like that. If you sued someone and you got a judgment on some item, you sue someone and say, that was my car, and you win the lawsuit, then now you can file a UCC 1 on that car afterward, or you can do more with it. Now you have a security interest in the car based upon law, not contract, right? It's important to keep that in mind. There's only two ways to establish security interest, by contract or by law. And you'll see in the video we're going to cover, Chris is saying that it was established by contract. And I don't think that's true. And we're going to cover why that is in the video, right? So, qualified right of property which a creditor has in or over specific property of his debtor as security. Okay. A claim is generally a liability. Let's see. No, we're going to skip that one. A lien is a charge imposed upon specific property, whereas an assignment, unless in some way qualified, is properly the transfer of... No. A lien is not a property in or the right to the thing itself, but constitutes a charge or security thereon, right? An estate in land is the right to the possession and enjoyment of it, while a lien on land is the right to have it sold or otherwise applied in satisfaction of a debt. That's very interesting. Okay. So the word estate, I didn't even realize this until just now. The word estate means beneficiary. I didn't know that. That's very interesting. The right to possession and enjoyment. So that wouldn't necessarily be legal ownership, you see? That's interesting. That's very interesting. I didn't know that. That's very new to me. While a lien on land is the right to have it sold or otherwise applied in satisfaction of a debt. Now again, that debt can be financial or performance-based. Keep that in mind. Liens are property rights. Interesting. The word lien is a generic term and standing alone includes liens acquired by... There it is. Right here. This is very important. The word lien is a generic term and standing alone includes liens acquired by contract or by operation of law. These are the only two ways you can establish a lien. Very important. Very important, right? here we go. This is where we see things like mechanics liens and stuff like that. Very interesting. Here we go. Some transactions or agreements held to constitute a lien are conditional sales contracts. Very interesting. You see that with my landscaping trusts that I had running. We should have done these with that on all the properties. We weren't doing it at that time, but we should have been doing that. Mechanics, working on people's homes, stuff like that. It's about $5 to place one of these liens, and then it's like $5 to take it off. A UCC3 is what you'll use to take a lien off after it's been placed. Let me show you that California UCC3 form. Let's see if I can find it rapidly. This is changes. Here we go. So this is a UCC3 form, which is an amendment, right? And right here, you can click termination. Effectiveness of the financing statement identified above is terminated with respect to security interests of the secured party authorizing this termination statement. So it's probably $5 to file one of these. So it's $10 to basically secure. So the first thing you would need to have is a signed contract. That's the original security interest, right? They owe you this amount of money and you owe them performance, right? Now on that, you could file a UCC1 on the home while you're doing your work or whatnot, right? And the security would be, you could even type that here. You could type like attached contract was signed for the following performance to be done in exchange for the following amount of whatever, and then it will be terminated upon this UCC1 will be terminated with the UCC3 upon completion of contract or whatever, right? And then at the end, you would file this UCC3 and you would terminate it and file that in once it's completed, and that would give you a much better standing in court if anything were to go wrong with the activity that was taking place. For example, mechanics, you've heard of these things like mechanic liens and stuff like that, right? So if we go back to the definition of lien, just right here, right? That's what they're talking about here. Some transactions or agreements held to constitute a lien are conditional sales contracts, right? But again, like I said a million times, hit in the course, you have to have the contract. It has to be established by contract or by law before you file a UCC1. A UCC1 is a notice. It's not the actual lien. It's just a notice. It's a public notice. It's like when you see places do a public notice because they're getting an alcohol license to sell alcohol on the premises, and they put up those huge boards with all that legal information. There's usually some kind of a hearing. A UCC1 is the same thing. It's just a public noticing. Like if the common law version of a UCC1 financing statement would be if, let's say it was 1842. And you loaned someone a horse on a payment plan, and they had to pay you 3 pieces of silver every week for 5 weeks, and then they paid off the horse, right? And you took that document, which would be handwritten and hand-signed at that time period, and you took it down to the county recorder, and you recorded it. So the recording of that original document, which was at the beginning, it was just private. No one knew about it, right? You're kind of bringing it into the public by going down to the county recorder and filing it with the county recorder, making a public announcement or a public establishment or a public record of the fact that this thing is there, right? But the thing is that the original charge or security, the original contract that was hand signed, is actually the lien. filing it into the county recorder in 1842 or in 2025 filing a UCC1 financing statement is a notice of lien. Do you see that? I know I explained this in the UCC3 6-part series, but it's always good to cover it again, and it's been a while, and it's always good to go over this over and over again because, in my opinion, as I've said many times, this area of liens and UCC1 financing statements is really the only area in all the sovereignty stuff you can really get in trouble with. I've never seen anybody get in trouble with anything else. This is the only thing I've ever seen. And I've also seen some people do it and get away with it. Don't get me wrong. I don't want to use fear tactics to make everyone be like, oh my God, I'm never going to file a lien ever. No, there's guys who I've talked to who have filed liens on judges and all sorts of craziness, and they didn't get in any trouble. But man, you're really playing with fire. I would never do it. There's no original contract or legal basis for the notice of lien. You see that? There has to be a previous lien in order to notice people publicly that there is this lien. It's very simple, right? Now we're going to get into Chris's argument, which his argument was there was a contractual basis. I don't agree with that, but we're going to get into that. So, lien by operation of law, where the law itself, without stipulation of the parties, raises a lien as an implication or legal consequence from the relation of the parties or the circumstances of their dealings, which would be a judgment, right? Liens of this species may arise either under the rules of common law or of equity or under a statute, right? Now, everyone's going to freak out on this because I've freaked out on equity so many times. Now, keep in mind, equity and law have been merged since 1938, the first issue of the Federal Rules of Civil Procedure. So keep in mind, they're talking about these three different things, right? And then also the common law idea is kind of confusing because in today's world, the courts define common law as case law, whereas in the sovereignty movement, we define common law as like jury trials where the jury just kind of looks over the information and then just kind of makes everything up on the fly, which is how things were done way back. Like if you got sued in 1820, or if there was a grand jury indictment in 1820, the jury would just say, and common law back then was notoriously violent, so they would just hang them. That was usually the solution for everything. Just hang the motherfucker in the middle of the town square, right? And that's actually why equity was created originally, because they wanted to soften how violent and intense common law typically was. But common law back then meant something different than what it means now. And I know a lot of guys in my comments and stuff who none of them have read any fucking cases. That's always the common denominator. They're very upset over the fact that the definition of common law in today's world means case law. But if you actually go out and read a lot of the cases, you probably won't have much of a problem with what's actually in the cases, actually. I've read tons of cases. I've spent this whole year of 2025 basically reading cases. This is the year of case reading for me. Didn't really read very many cases, if any, prior to that point, sadly. And today, starting at the very end of December of last year, early January this year, I started reading cases. I just didn't stop for months. And that's kind of where the treatise on the word person came from, and the whole shift over to, a white citizen of a state and kind of that whole thing. And that's kind of still developing, but we're at kind of the near the end of that cycle, right? So liens of this species may arise either under the rules of common law or of equity or under a statute. In the first case, they are called common law liens, in the second, equitable liens, and in the third, statutory liens. I'm not so sure you're going to see a lot of that terminology in today's world, but you might. We're not going to get into all this. Let's see what else we have here. One whose property is subject to a lien is a lienee. Then you have the lienor, right? Let's see here. Lien account. So there you go. I think there's just a lot of confusion on this still, even after 2.0. You know, what is the lien? The UCC1's not the lien, right? And nobody knows what a UCC3 is either. There's so many people out there teaching where you file a UCC1 and then you file a UCC3 right after it, but that's not. UCC3 is to amend a UCC1. Why would you need to amend a UCC1? The only reason why you would need to amend a UCC1 is because you need to amend a UCC1. There's no other reason to do. If the UCC1 is correct at the beginning, then you wouldn't need to file a UCC3. You know, because again, look at it, right? Amendment. So why would you need to amend a UCC1 if it was done correctly, right? Continuation. So like mine, when we get close to the end of it, I'll probably let it die off and file another one because I want to change the wording because after 5 years, everything's going to be so much different. My understanding is going to be so much better. But if I wanted to continue it, I would do a continuation. And if I wanted to assign it, I guess this is kind of what Chris was trying to do in his case. You'll see that in the video we're going to watch. Assignment, right? You can assign it to somebody else, and then you can also terminate it, right? So assignment means to move it, full or partial, right? I'm assuming you move the secured party. So it's kind of an interesting idea. It's sort of like you could sell your security interest, right? It's sort of like this. It's like the stock market. You have the security interest, and let's say you sell half your security interest. You file a UCC3, and then you do an assignment, and then you assign half of the security interest over to the person you sold it to. I'm just talking out of my ass. I'm just, looking at this and kind of looking it over, right? So yeah, but again, keep in mind, this is all still just notices. So you and I would have already had a contract, and you would have already maybe paid me or whatnot before I'm going to file a UCC3. The UCC3 is not going to get filed until whatever agreement we have is either contractually or legally activated. Otherwise, you wouldn't go and file a UCC3 yet, right? It'd be wrong order of things, right? I'm going to close some of these windows. I'm getting a little bit lost here. Close these. Close this. Close this. There we go. So, Mr. Burton further explained that a UCC financing statement is a document that is filed when a business transaction involves a loan or performance, which we already covered. The UCC1, as it is commonly called, does not create a creditor-debtor relationship. It merely, quote, puts the world on notice, end quote, that a creditor may have an interest in the collateral used to make the loan. This is correct. And this is what nobody really realizes. This is actually correct. And it's not that a creditor may have an interest in. It's that a creditor does have an interest in the collateral used to make the loan, right? Mr. Burton explained that UCC filings are received by the Secretary of State's office, filed and recorded on a server in Nashville. They can be filed either in person or electronically. Mr. Burton explained the steps to electronically file a financing statement on the website of the Secretary of State. To file the document electronically, the submitter is required to provide his or her contact information, the contact information for the debtor, the contact information for the secured party, in this case, the submitter of the financing statement, submit a value for the maximum principal indebtedness. I don't think I did this on mine, and I don't really know. I think this is more like just what people usually do. I don't think this is actually a requirement. I could be wrong. Describe the collateral. That has to be done. And pay a fee for the filing. The value of the maximum principal indebtedness is assigned by the submitter of the information. See, it's like a very, very, it's just kind of whatever the person puts on there, right? Mr. Burton admitted that he was unsure how a submitter determined the maximum principal indebtedness, explaining that he thought it would be equivalent to the value of what was being financed or the submitter's estimation of whatever the collateral might be worth. That's the part where I'm kind of like not too sure. That's actually part of, everyone does it, but I've never seen anything in writing that I think everyone just does it because everyone else does it. It's one of those things that, like, all the sheep are running in one direction, so new sheep come and they just start running in the same direction, kind of a thing. I could be wrong, but I didn't put that in mind because I didn't know if I was just running after the sheep or if it was something real, and I couldn't establish one way or the other. So I never put that in there, right? Plus, values fluctuate so much, so it's just, I don't know, it just seems weird. But nothing, I mean, you could do it, right? The financing statement requires the submitter to sign the document electronically and agree with 2 attestation boxes, one of which, quote, basically says that you understand it is a felony to file a document with no underlying debt, end quote. Now, this is it right here. Again, it's a notice of lien. So there obviously has to be a lien underneath it. Otherwise, it's a felony because there's no underlying. You're saying there's an underlying debt or lien when there isn't. It's basically fraud essentially, but you would have to know that you're doing that in the moment for it to be legally classified as fraud, as we looked at earlier in the definitions, right? The submitter must also use a credit card to pay the associated filing fees. Once submitted, the information is placed, quote, on a server that's located in Davidson County, end quote, and is also publicly available on the Secretary of State's website. During the testimony of Mr. Burton, the state admitted over 100 exhibits. These exhibits contained financing statement documents, generally including a UCC-1, a UCC-3, payment documents and receipts in several cases, documents concerning termination or removal, which would be through a UCC-3. During the admission of each of these exhibits, Mr. Burton testified similarity. He described the UCC-1 financing statement as the document submitted electronically. He testified to the name and address of the person submitting the document, blah, blah, blah. The amount listed on each lien varied from $4 million to $12 million. One example included the following language in the collateral description. Claim of lien, May 23rd, 2016, in the amount of $8 million in the money of account or in lieu of the money or in Federal Reserve notes or a bank draft to United States dollars of whatever currencies prescribed as lawful currency in satisfaction of all debts, public or private, in the county. It's a bit confusing. This whole part is kind of confusing to me. It's just kind of weird. This particular UCC-1 listed the maximal principal indebtedness as 0. The UCC-1 was accompanied by a UCC-3 amendment to the original financing statement, which assigned the UCC-1 to the U.S. Treasury in Washington, D.C. for collection. Mr. Burton explained that a lien based on a UCC-1 lapses after 5 years unless they submit a continuation, which we saw on the UCC-3, box 2 or 3 continuation box, within a 6-month period, extending the UCC-1 for an additional 5 years. Let's see here. So that gives you a background on what we're looking at, right? So all these guys went to jail. Some of them I think are still in jail. Chris Hauser went to jail. He got out. He got like 20 years, but he ended up getting out in like 2 or 3 years, if I remember correctly. Let's see here. They put all the different liens in 102 manila files. Chris Hauser objected because the value of the document was contested. The trial court explained that it would use, quote, the amount, and then there's more words there that are not listed here, listed on the financing statement, on the financial statement. The court explained that the label would contain the following information: the financial statement amount. Okay. Okay, we got some other stuff here. So it looks like they were paying each other to file these liens. That puts it into a commercial activity in itself, which is pretty bad. Defendant Cooper told Mr. Birdsell that he charged $6,500 for his help in filing liens. Mr. Birdsell gave Defendant Cooper $500 in cash that night, but eventually paid him the full $6,500 in exchange for help in filing liens. That's definitely a huge no-no, because that puts it into a commercial category, the activity itself, right? Let's see here. Let's go down to Mr. Hauser. 21 counts filing a fraudulent lien. 21 counts of forgery with the jury affixing value of $250,000. 2 years for each conviction for filing a fraudulent lien and 20 years for each conviction for forgery to be served concurrently for a total effective sentence of 20 years. That was the sentence and convictions. Okay. But like I said, he was only in there for a few years, I think. Let's see here. I think he was only in for a few years. On appeal, they brought up a venue for defense. Talking about venue, I'm not really going to get into that. That's just procedural crap. Something about a shooting or something, I don't know. Anyways, so this is the background I wanted to give you on this. And I don't know everything about this. I was trying to kind of peck around quite a bit to try to figure it all out. But from what I can tell, it looks like Chris and maybe other people, I don't know, filed for post-relief. So like he's saying like all that craziness and going to prison and kind of all that stuff is bullshit, and I need like post-conviction relief, essentially. You'll hear him talk about that a little bit in this video we're going to cover, right? And this is now the docket, which I'll put down in the video notes. I'll put all these different links and stuff all down in the video notes for you guys to look for yourself. You don't need any sort of login on this, which is really nice. You just click on any of these, and it'll pop up, and you just click on this, and it'll give you the file. So you guys can dig through here if you want. I don't see anything terribly important in here. I've dug through several of these before I started this video, but I wanted to do this video today because this just happened earlier today, and it's so cool to see. So let's go ahead and get into this video now, and then I'll stop and we'll talk about it kind of as we go, okay? Let me just make sure I'm with you guys still. Good. And let's get popping here.
Exit. A little quieter.
Yeah, I understand, Your Honor.
Now, first and foremost, you know, I'm gonna say some things about this that I'm not particularly thrilled of, but I want to say this is so fucking cool, and I really, again, like I said at the beginning of the video, I really wish we could have more of these and see more of these. It's just so cool to see this, and I just wish we had more of this stuff. So if any of you guys are going in for hearings, try to get the videos. If it's videotaped, try to call the clerk and see if there's some way that you can bring in your own audio recording equipment. Like, play by the rules, but see if there's some way, is there already going to be something, or, transcripts are cool, but you can't see a lot in the transcript. Video or audio is way better. Okay, guys? Now this is, by the way, this is appeals. So you can see, just like in my cases in the Ninth Circuit, when you go to appeals, it's a panel of 3 judges that kind of all work together, which is really a cool thing about appeals. So in the district level or state level, you're going to have 1 judge. Sometimes there's a magistrate or whatnot. At the appeals courts, you'll get 3. I mean, it's the same in his district or his circuit. It's the same in my circuit. At the federal level and at the state level, you're going to see 3 different justices all kind of working together. So that's one thing that's really cool about appeals cases, in my opinion, right? Let's pull this back up. So this is Chris Hauser, for those of you who are aware who he is. He's right here. He's got his hair back. He's got his button-up shirt on.
If it would pleasure the bench, my name is Christopher Allen Colon, family of Hauser. I am a sovereign.
So right away, I did this a long time ago on the 1.0 course. I was talking about the hyphens and the colons. That comes from quantum syntax grammar, which comes from, I forget his name, David Windmiller and his buddy, the guy who says that he's the postmaster general or whatnot. I forget his name, Russell J. Gould, right? It's something that I don't use anymore. I don't think it's going to do anything more than just confuse people. It's a way of trying to separate your identity from the whatever, right? I'm not a huge fan of it personally. I don't recommend it or use it anymore, and I've taken it off of everything that I used to use it on. And then in terms of sovereign, there's only one class of sovereign, and that class is given by Roger B. Taney in Dred Scott versus Stanford. And we're going to go ahead and read that. I cover it everywhere. It's in my book like crazy. It's also on the treatise, so we're going to cover it here again, right? The words people of the United States, referring to the preamble, we the people, and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. And this is where it hurts me so much, because I said sovereign citizen is horseshit, and I said that it's an oxymoron for so fucking long until I started reading cases. And a lot of things have changed since I started reading cases. And this is one of the biggest things that have changed since I started reading cases. Now, keep in mind, Roger B. Taney, let's just talk about him for a moment, right? Roger B. Taney. So at this time, this is 1857. So at this time, he had already been the Chief Justice of the Supreme Court for 21 years by this point. So it wasn't an off day. He wasn't a little too drunk. It wasn't like, there was a lot going on with this case too. So it was obviously an important case. So if you look at his background, I wonder if we can show something simple. Yeah. So he was the Attorney General from 31 to 33. He was the Secretary of War for a short time in 31. He was the Attorney General of Maryland from 27 to 31. He was a member of the Senate in Maryland from 16 to 21. He was a member of the Maryland House of Delegates in 1799. And then he was the Secretary of the Treasury from 33 to 34. And then he was the Chief Justice of the United States from 36 until his death. He died October 12th, 1864. So in today's world, you would look at this as something very negative. In today's world, you'd be like, oh, he was in the government his whole life. What a piece of shit. Like a Joe Biden kind of a thing, right? I understand that, but back then it was totally different. Guys like him, guys like John Marshall, these guys love this country, man. I'm telling you, for those of you who aren't aware of Roger B. Taney's writings, this dude loved this country and literally died for this country. Like, I'm not kidding. Totally, right? John Marshall, Roger B. Taney. This is a totally different class of American that we don't even see in today's world anywhere. Doesn't exist, right? So when you see this, I want you to realize that I understand that this kind of a thing in today's world just means that they're a piece of shit and their net worth is $400 million, and even though they're only making $140,000 a year, how's that possible? Blah, blah. I get it. That's what you hear all the time. You're Nancy Pelosi's, you're whatever, right? I get it, right? But I'm telling you, this is different. This is different. These guys were operating, if you go down the history track and you start researching, these guys were operating out of people's homes in Washington, D.C. They didn't have like an actual building. Like they were operating out of people's homes, like they were operating out of like lodges, probably Freemasonry lodges, probably other kinds of lodges. That they were. It was some fucking like saddlebag shit, bro. And like the Supreme Court didn't even have a building until like, when was the Supreme Court building built, right? Like 19. So this is way before they even had their own building. They used to have parts of the White House, and they'd get moved to a different part of the White House to do. They had houses, lodges. Like when you really go back and research, this is a completely different America. This is the America that I want to get us back to, right? That's the whole point of my whole platform. So everything you think you know about what all this means, you have to throw it out the window. It's totally different. These guys were doing whatever it takes. They had friends. It was houses. It was fucking whiskey and fireplaces. I'm telling you, right? And it was fucking awesome. It's the most American thing in the world when you realize this is what America's all about. America's about building something huge and amazing out of fucking nothing. That's the definition of an American. And you'll see that in my book if you buy it and read it. If you're not aware of my book, for whatever reason, I will show you that. This is where we cover the entire history of all of this, right? This is my new book. For those of you who aren't aware, you can get it on Amazon. It's called The Guide to the Most Beautiful Woman in the World, the United States of America, right? And it's a rewriting of an old Army training manual from 1928 about citizenship. And here's a video talking about its meaning and how it was built and everything like that. And you can get signed copies if you want, or you can buy hardbacks, paperbacks, audiobooks, and ebooks on Amazon if you want to learn more about all that stuff, right? But keep in mind, so he's 21 years into being the 5th Chief Justice, so he's the highest legal person in the country. Legally, it doesn't go any higher than the Chief Justice of the United States Supreme Court. That's it. Top of the tier, my brother. So 21 years, he's top of the top, tippy top of the top of the top. And this is what he has to say about the situation. He's saying that sovereign citizens, these people are sovereign citizens. The words people of the United States and citizens are synonymous terms and mean the same thing. They describe the political body who, according to our Republican institutions, form the sovereignty, literally sovereign citizens. There's only one type of sovereign in America, and it's a sovereign citizen. And those sovereign citizens are white people, a free white person, who is a citizen of one of the 50 states of the Union, not a U.S. citizen. That comes way later. When he said this, and I cover it in my book, and I cover it on the treatise, I think, the definition of a U.S. citizen, there was no definition of a U.S. citizen. It was just a colloquialism that people would use as something easy to say, but it was only in relation to which state that they were a citizen of. You'd say, oh, I'm a U.S. citizen colloquially, and the correct legal response would be, oh, of what state? Oh, way back then, it was, we didn't have as many states as we have now. So let's say New Hampshire would be the answer to the question. Oh, you're a New Hampshireite. Yes, I am. Oh, that's so cool. Nice to meet you. That would be how the conversation would have gone back in 1857 or before that point in terms of that kind of thing, right? So when Chris Hauser says he's a sovereign, he's not explaining that he's white. Obviously, he's white. You can look at him and see he's white, but he's not saying I'm a citizen of Tennessee. That's what it is. I'm a sovereign citizen of Tennessee. Would be the only way you can say it. You can't say it any other way. I'm a sovereign citizen of Tennessee, and as you can see, Your Honor, or Your Honors, I don't even know how you'd say it with three guys there. As you can see, I'm white. I'm a free white person or a free white man. That's how you'd say it. And that's not me telling you because of my own ideas. That's all this case law. You go back and you read all this case law. They use the term free white person, free white man, white man. That's what they say. I'm just saying what they say. I'm trying to get away from having our own terminology because this kind of stuff, you take the guy who's the very top legal authority in the entire fucking country 21 years into his tenure, and he says something, this has massive fucking weight. And people will say, oh, Dred Scott was overturned. Yeah, I understand. But this is not like part of the opinion of the case. He's not talking about Dred Scott or slavery or citizenship or Negroes here. He's just making a statement. This is not something that is overturned because the case was overturned. This has nothing to do with the opinion. This is just him You should see how long his opinion is in this case. It's the size of a fucking book. So it's just him just talking. He's just talking. It's like everyone knows this. This is the way it's been. This is the American structure. He's not saying anything about the opinion about Dred Scott and Negroes and released slaves and citizenship here. That's horseshit. This idea that this quote no longer applies because Dred Scott was overturned is fucking ridiculous. What this is I've been here for 21 fucking years. And I am the fucking man. And this is the situation. It always has been. And as far as he's concerned, as far as he would like to see, it always will be. So keep in mind, when I read this, it changed everything. Fuck. The state national thing's got to go, and I was wrong about sovereign citizen, and, there we go, you know what I mean? And I got to walk through town square and get fucking tomatoes thrown at me. Okay. Luckily, everything's free, so you guys can't complain too much or I just block you, right? If I charged all you guys for all that stuff I did in the past, I'd probably be feeling pretty bad right now. But because I didn't, I have no real qualms about the fact that we have to make these shifts, okay? So with that said, let's get back to this video. I know it's a lot, but I think it's good. I think you guys will like this. I've been watching, you can see here, I've been watching Nick Fuentes. I did a super chat on his show the other day, and it was super funny. And I've been watching a few of his shows because I was so curious. Like, man, he's really blowing up right now. He's got like 60 to 80,000 people live on every single show, every single day, Monday through Friday. He does a show Monday through Friday, every single night. He's got 60 to 80,000 people live on the goddamn thing. And he's just really, after his Tucker Carlson interview, he's just blown up. And I'm like, damn, what is it? This guy, obviously, so I started watching his show on purpose to try to find out what makes people want to watch his show, especially young people. It's all young men, right? And I started watching it, and it was really, he's just like talks, and he talks about his own opinions, and I thought to myself, in 1.0, I would go off on these long tangents, and I would talk, and I would fucking joke and sing and do all this crazy shit. And in 2.0, I took all that away, and it just became like totally fucking, this is what to do, and it became all fucking business, right? And I decided I'm going to start making more videos. I'm going to try to like merge the two together somehow, try to bring back some of that flavor from 1.0, some of that fun and some of that excitement, which is kind of what you see with Nick's show. And but I want to obviously make it very informative and very very usable. We're never gonna go back to 1.0 completely. I don't want to. I'd rather kill myself. But I just thought about it and I was like, you know what? I should do more videos. I should do more critique videos. I should do more kind of long monologue-y type stuff. And overall, I think you guys will like it because a lot of you guys still love 1.0 and I can't stand 1.0. And I think what you guys like about it is the fact that I would monologue and tell my thoughts and do crazy shit and all, you know. And I think that's something I kind of want to infuse more into the videos and kind of get more into 3.0, which is probably coming fairly soon. I'd say in the next 6 months or who knows. But anyways, back to this video. Let's get back to this video.
I am a son of the Most High, a sovereign according to the Tennessee Constitution, Article 1, Section 31.
One question.
Article 1, Section 31, Tennessee Constitution, Article 1, Section 31. Article 1, Section 31. Let's see here. Really? The 1870, I probably wouldn't be too thrilled about that one. Let's see here. Article 1. Let's take a look here. Tennessee Constitution 1870. Article 1. Bro, really? I can't read this. Article 1, Section 31. Let's see here. Article 1, Section 31. Let's see what happens. There we go. Interesting. So you're seeing latitude and longitude. That right away indicates pre-statutory, right? Talking about the different locations. Let's see here. Over which the people have the right of exercising sovereignty and the right of soil, so far as is consistent with the Constitution of the United States, recognizing the Articles of Confederation, the Bill of Rights, and Constitution of North Carolina. Wow. That's pretty cool. So that's actually a great way of saying it, actually. He kind of nailed it there. He didn't necessarily say he was a citizen of Tennessee, but by saying that he's a sovereign in accordance with this, I mean, you really can't argue with that, now can you? That's pretty good, actually, now that I think about it. Just a different way of saying it, right? He's basically saying, I'm a citizen of Tennessee. That's what he's saying, because if he wasn't a citizen of Tennessee, he wouldn't be a member of that sovereignty, just like we saw with the quote from Mr. Tanny, right? Let's get back into this.
First, did you want to reserve any time for rebuttal?
I don't believe I'm going to need to rebut. I think by the end of this argument that I have, there won't be a need for it personally. I am the beneficiary et al., appearing specially in propria persona, not pro se.
So this is kind of like what I taught in the 1.0 course as well. He's still kind of on the same bent. He's talking about it on behalf of the Sestake Trust or whatever. The problem is if you start, I've been in enough courtrooms to know, if you start talking about trusts, they're going to say you need a bar card to represent the trust, right? And as you guys have seen in all of my cases, I've been saying sole proprietorship, and they don't have any issue with it. They're not freaking out and saying that I have to have a bar card by saying sole proprietorship, right? And you can see right here, it's very easy to talk about this or prove this. If someone has a question or if somebody wants me to prove something, I would just whip out a W-9 and I would say name of entity / individual. An entity is required. For a sole proprietor or disregarded entity, enter the owner's name on line 1 and then the business / disregarded entity's name on line 2. It's telling you there's two different things here. This would be the owner. That's how they say it. Enter the owner's name, and then business name / disregarded entity would be the business name or disregarded entity's name, the sole proprietorship's name. So the idea that it's the same thing is just silly. It's owner of a business. I'm not a business. I'm not an entity. It doesn't make any, it's like, this is very simple. This makes it very, very simple. Yes, the owner has a financial responsibility on behalf of the sole proprietorship, but it doesn't mean that myself and the sole proprietorship are the exact same thing. That doesn't make any sense. I'm not a business. I'm not an entity. You know, it's very simple. I don't see as to why it has to be so much more complicated than that. To me, it's really that simple. And when you do it that way, as you guys have seen in my cases, I've never had any issues or being told that I need a bar card to represent the sole proprietorship. So it just avoids all that. You're not going to see him fall into that pit hole here in this video, but I'm telling you, myself and Joey have gone through it many times or seen it many times. And I'm telling you, it's a real issue. And so many people in my comments and stuff like that, they go, oh no, equity and private trust and all this. And then I go, okay, do it. Watch what happens. And they go in and they do it. And it's like, if there's a trust, there has to be a bar card to represent the trust. And they freak out and they're trying to figure out how to do it. I've never seen anyone get around it. So I'm not saying you couldn't get around it, but do you want to spend months and months and months fighting that one point? Or do you want to just say sole proprietorship and be done with it, right? And then pro se versus sui juris, I don't think there's any difference. I don't think anybody gives a flying fuck, personally. And anyways, who cares? I just don't. It's irrelevant. If it's a sole prop, it's a sole prop, and you're a state citizen, and that's it. It's very simple.
I'm sui juris, and the beneficiary of the Social Security Sesticate Trust, the all caps name Christopher Allen Hauser.
Are you the defendant, Christopher Allen Hauser?
I would be Christopher Allen, the beneficiary of the all caps name.
So that's a no or yes?
I would be, you would consider me, the state would consider me as the defendant.
Okay.
Okay?
Go ahead.
To answer your question, there's one question.
So that's a very interesting. Frankly, I would say the reason why they kind of softballed him is because they do know probably by this point that he has a very large following online, a big YouTube, all this kind of stuff, right? And also, when they're video recorded, they have to be a little bit more careful in terms of, public outcry or what could happen. And I've never, ever, ever once seen this kind of a thing. Are you the defendant? It's just like, oh, there's a trust? Okay, great. You have to have a bar card to represent the trust. Where's the bar card? Oh, you don't have a bar card? All right. I'm either going to give you 30 days to get a bar card and come back, something like that, and then that's it. And they kind of throw you out. I'm telling you, I've seen it so many times. And again, the reason why so much has changed on my platform, and the reason why I say things that other people may not be doing or saying, is because myself and Joey, we read a lot of cases. We get sent a lot of cases. We read a lot of cases, mainly civil cases. But I'm telling you, our opinions at this point, as of this year, are based off of cases and reading cases and seeing what's really going on out there. So for people who want to go out and say trust and say this, do it. And watch what happens. You'll come to me and you'll say, yeah, I did the trust thing and I got told I need a bar card. And duh, I would have told you that. It's easy peasy, right? So they didn't do that. They just said, are you the defendant? Which is a fascinating question, right? And you can see. Now, one of the things I wanted to say about this is he's doing a fantastic job. I'm not really a fan of the technicalities of the things that he's saying anymore. I was at one point at the very beginning. But he's very calm. He's very composed. He's answering the questions. He's standing there. He's being respectful. He's not freaking out, yelling, anything like that. I really like what he's doing here, frankly. I mean, you got to think when you go to court, it's not what's right or what's wrong. It's about how well you know things, how confident do you feel about things, and then how hard are you willing to push your claims. You can push all sorts of goofy claims that I would consider to be ridiculous, but if you have enough gusto and you believe in them enough, you'd be surprised what people can do. It's more of an open book than people would think, okay? With that said, let's get back into this video.
Does this court recognize and adhere to the decisions made by SCOTUS? It does. I assume you're acquiescing. So, if so,
he's asking if they follow the Supreme Court's rulings, and they either barely acknowledged it or didn't acknowledge it, and he just kind of said, "Okay, take that as a yes," and moved on.
The United States Supreme Court declared in 1969 the ability to place a lien upon a man's property, such as to temporarily deprive him of its beneficial use without any judicial determination of probable cause, dates back to medieval England, but also to Roman times, unquote. That's Snydash versus Family Finance Corporation. According to this decision, there is no need for legal basis per Tennessee Code annotated 39-17-117, A1, where it states, when such person has no reasonable basis or any legal cause, unquote. But we did, however, go the extra mile to create the reasonable basis and legal cause, evidenced by common law contract created via the postal rule.
So what he's explaining here is explaining, again, a lien can only be established by either contract or law. That's what he's talking about right now, is how these liens were originally established.
This contract is referred to as the conditional acceptance. You'll find that as Exhibit A for ID only in the case. That's the contract. The next point I'd like to get to is the withholding of exculpatory evidence.
So the postal rule is the one that I was teaching at the very beginning, because I was teaching a lot of Chris Hauser stuff at the very beginning. It's where, and he'll talk about this a little bit more later in the video, but it's where you would send them something, and then they would sign for it. They would sign for it with the certified mail, and then they basically would essentially be agreeing to whatever was inside the envelope based off of them signing for it, which I taught that in 1.0, but since then, and studying all the stuff and looking at everything, I'm absolutely positive that would not establish any sort of contract. And you'll see the justices in this case, we'll talk about that briefly here in a bit.
We did, in fact, have a valid contract with the legal victims by the states interjecting themselves in the middle of the contract. This would be considered interfering with the obligations of contract, which would make this a Brady violation, Brady versus Maryland. Along with the controlling case for Tennessee is Tommy Newley versus State of Tennessee, Supreme Court at Jackson. In the transcripts, they start at page, the court transcripts, the hearing transcripts. They start at page 603, line 12. The jury exits the courtroom. Then there's a conversation between the alleged defense attorneys and the prosecution for the state and Cheryl Blackburn, the judge of Division 3. If you read that, 603 through 605, you'll see that they discussed removing the contract from the out of the sight of the jury. This is considered withholding exculpatory evidence. They there was two things that they marked for ID only, Exhibit A and Exhibit B. Exhibit A is the contract. Exhibit B is the affidavits that the public officials filed, removing the UCC ones.
Now I want to stop for a second and just kind of talk about his body motion, his eyes. He's making eye contact. He's using his arms. You can tell by the way he's turning the pages. He's nervous. I mean, of course he's going to be nervous. Everybody's going to be kind of nervous in this situation, right? But I just think it's great. I wish I saw more of this. Man, I wish we had lots and lots of people doing this kind of stuff and recording it and sharing it, and then we could all do different critique videos. I'm telling you, you guys want to get together in these little groups that don't do fucking jack shit, and you guys want to sit around and circle jerk each other and beat off on each other's chests, and I don't know what you're doing. It's disgusting. I can't even stand my own fucking group, barely. I don't know what, this is the kind of, if you guys want to get into groups and do stuff, this is the kind of stuff you should be doing. Getting these hearings, getting the videos, sharing them, critiquing them. It's really cool because you're seeing it. We're seeing this happen. You know, I'm gonna probably say that a few more times as throughout this video because I just really want to see it. I really want to see it, dude. This just happened. Like I just found out about this like hours ago, and this just happened like 8 hours ago. So I'm already making a video about it. It's middle of the night. I got my ring on, my light ring on because I was so excited that I just wanted to jump on this thing and do this. How cool would it be if we had, one of these a month, and then after that it's going to be one every 2 weeks, and then one every week, and then everyone's talking about it. It's going to be so much better. So I just wanted to say that. Let's continue.
Off of their out of the state's record. This law came about because of what we did in the winter of 2017.
Did you have a security agreement with these public
Yes,
officials?
we did.
See that right there? Did you have a security agreement? Yes, we did. Right. So here we go. This is how is it established, by law or by contract? Remember?
And they signed it.
And they signed it, meaning by contract.
They signed it. If you understand the postal rule, when you send something certified mail, return receipt, the little green card comes back. That is the signature card.
Well, I understand a contract requires a meeting of the
yeah.
mind. Did you have a meeting of a mind that this was a security agreement?
Yes.
See that? That was a beautiful question by that justice in the middle. I think it was the guy in the middle who asked that. Beautiful question. Beautiful question. Now, another thing I want to say on this, we see so much stuff about people going in and stuff happening, and then they come out and they say all the justices are Freemasons and they're all eating babies and all this kind. I want to say how cool it is that these justices are there. If you notice at the beginning of the video, when Chris opened up his thing, or when he started talking, they all opened up their things. They started making notes. They've got their water. Like, this is not, you guys, people get upset because they go in there and they scream and they yell and they act like fucking lunatics. The judges are fuck you. The judges say fuck you. And then they go home and they say Freemasons and aliens and eating babies and sacrificing children and all this kind of stuff, right? And I want to show you, it's so cool if you just calm down and have a conversation, even if you say some crazy shit. These guys are obviously pretty cool. They've asked only a couple things so far. What did they ask before? They asked, are you the defendant? And then now they're saying, was there actually a contract? Did they know this was a security agreement? Great question. Those are the exact question I would have asked in this situation if I was on the bench. Was there, how was this established, by a contract or by law? By contract. Okay, great. Where's the signature on that? And did they know that it was a security document, exercising a security interest or creating a security interest, right? Phenomenal question by the justice in the middle.
And the security agreement, the state continued to call it a lien. And the UCC1, if you guys remember, if y'all remember the case, you heard it. If you go back on your YouTube channel, There were 10,000 views on that hearing, 40,000 on the Supreme Court case. I'm viral YouTube, content creator. So they signed those sworn affidavits saying that they had no contract, but in the affidavit they speak about the contract. They did that in the summer, roughly, in the summer of 2017. Then they came back in 2018 and testified they had no contract. But they read the UCC1 filings that said, under common law contract number, blah, blah, blah. Every one of them, every one of the witnesses, they either said they had no contract or they got something in the...
Now, real quick, meeting of the minds, right? What is a meeting of the minds in contract law? That's what the justice in the middle had asked, right? Let's go to... let's see. I do like Cornell quite often. Meeting of the minds refers to mutual assent by all parties in the formation of a contract. For a meeting of the minds to occur, the party must agree to the same terms, conditions, and subject matter. Although a meeting of the minds was required under the traditional subjective theory of assent, modern contract doctrines requires only objective manifestations of assent. Nowadays, a meeting of the minds remains a required element for a valid contract, but is judged only by the outward expressions of the parties. Thus, a meeting of the minds occurs even if one party subjectively did not agree, as long as both parties' outward expressions manifested assent. Kind of complicated. But I don't think this whole postal code thing is real at all. It doesn't make any sense. I can stick in an envelope that I own everything that you have and I own your car and then send it to you and you sign for it and then I just come pick up all your shit with a tow truck. It doesn't make any sense. The whole society would break down and explode. You can sue someone after sending them something like that and try to get a default judgment. If you get a default judgment, I suppose it'll work. But even if you get a default judgment, it doesn't mean that there was ever a meeting of the minds. It just means that your claims become fact because they never bothered to respond to them. So it's still, but on the merits of the idea of meeting of the minds, there is no meeting of the minds when it comes to the postal rule, in my opinion, at all. And if I was a justice, I would never allow that in my courts, not in a million years. And it just doesn't make any sense, I mean, the only way maybe you could construe it is by saying that the corporation assented because the corporation is a person. I don't know. I don't even know how you'd... Anyway, but I just don't... It doesn't make sense to me. So the idea that there is a contract here because they signed the certified mail slip, I can't agree with that. I feel like that would destroy everything. It would destroy the whole society. It's not a meeting of the minds. And that's the first question that one justice had is it a meeting of the minds? And he's explaining that, right?
Mail, which is the contract. According to the postal rule, when you send me a summons to court, you send it certified mail. I agree that I'm going to be there when I sign that. That's why they send stuff certified mail. That's you creating a contract with whatever court is bringing you in that you agree to show up. If you don't show up, they rule in favor of whatever. In this whole situation that we have,
But the thing is that you can get a default judgment on somebody by summoning them and they don't show up. But it doesn't give merit to the idea that there was actually a contract and a meeting of the minds. You're not winning on merits. You're winning on just straight procedure. It's just it's a purely procedural victory by getting a default judgment. So I feel like he doesn't understand the differences between winning procedurally and winning on the merits, because you can win all sorts of crazy. You could say that some, person owes you this and that and all sorts of goofiness. If you win procedurally, your claims become fact, even if they weren't actually fact to begin with. So it's two separate things.
They signed sworn affidavits, and then they turned around and committed aggravated perjury, every one, including my ex-wife. I'll get into that. So that's our argument on withholding exculpatory evidence. That's evidence, I'm sure you all know, that's evidence that may or may not have vindicated us.
Did you raise that on direct appeal?
No.
See, now that's another huge problem. Is that's why they asked that. So the reason why he asked that is, did you raise that on appeal? It's sort of like, if you don't raise these objections early or like right away or when they happen, you have no right to really raise them later, essentially, basically, right? So he's saying, like, at that time, did you bring that to the awareness of the appeal? And he's saying, no, that's rough. Because it's sort of like, so it wasn't a problem then, but now it's a problem. You know what I mean? Like, it doesn't really, it's Joey calls it, shit, what does he call it? He calls it, preserving the record or preserving the idea, right? You always want to bring up objections. That's why you have things like objections, right? If you don't object, then you only have so much time to object. It's just like an appeal. If you want to appeal, you only have so much time to appeal. If you don't, then that's it. You can't really bring it up anymore. That's kind of why they're asking that. It's based off of the rules and stuff like that, right?
Raise anything on direct appeal, and I'll answer that question just briefly. The other issue is severance.
So here they asked if it was brought up on appeal. He says he's going to explain why it wasn't brought up on direct appeal, but then he just kind of veers off and goes back onto whatever it is that he's looking at. He just veers back onto whatever it is that he was saying before the justice asked him that question, which doesn't make sense to me. It's like, I would answer the question and not veer up back off onto what I was talking about. Because if they have a question and you don't answer the question, they're not ready to go back onto whatever it is you were talking about, because their attention's over here on the question they just asked you, and you haven't completed that communication. So it's sort of like they've thrown a ball in there, and you just kind of set the ball over here. They're thinking about that ball now the whole time that you're talking. Whereas if you would have just addressed the ball as soon as they threw it at you, if you want to go even farther, you could even ask the justice something like, does that answer the question for you satisfactorily, or do you have any other questions on that? And then if they don't have any other questions, then you would go back to whatever it is that you're reading. That's just basic communication, in my opinion. But again, it's really easy for me to sit here and critique this here in my comfy chair with my light on than it is to do all this kind of live when you're there. That's why, again, if more people were doing this and more people were talking about it and it was happening more and more and more, we'd all be able to learn this and do this together, and we'd be able to get through all this and kind of figure all this out at a much faster rate rather than just a few people doing it and a few people barely piecing it together. So let's continue.
We filed post-conviction. I filed post-conviction on behalf of myself et al., the rest of the guys that's in the group. I sent them, I mailed them out via the postal rule from Newport, Tennessee on the 9th of May. I sent one copy to Jonathan Skermetti. He got his on the 13th of May. I sent one to Cheryl Blackburn. She got hers on the 15th of May. The one that went to Joseph Day was, this is, and it should be in the record, this is the signature card that he signed. If you'll notice up here in the corner, the date's been changed to 5/16. I've got friends, I'm a veteran, I write claims, help veterans get benefits in East Tennessee for the Department of Veterans, the DAV. I've showed it to guys that are retired military, retired postal worker. Hey, what do you think of this? Oh, well, they've altered the date. That's where we were refused post-conviction relief at.
Post-conviction relief. See that? I believe that's what this case, it's an appeal for some kind of post-conviction relief.
When the severance, they lack jurisdiction. The motion to sever during pretrial and throughout the trial were denied, according to Tennessee rule, a criminal procedure, Rule 14.
And again, like you can see, he's getting a little bit flustered there. This is one of those things that you just have to do it over and over again. Like when I went in for my small claims case, and I couldn't get the audio because it said it was broken or whatever. I was absolutely terrified up there talking. I did a pretty good job, I think. I think there was like 10 or 12 people that had driven to come see me do this. So we had an audience there. And I was super nervous. And I got up there and stuff, and it's like, even if you have your documents, you don't really have any time to like go through them. So they're kind of pointless to even have. I knew it all so well, just off the top of my head, that I was able to talk about the situation and talk about, I had a draft, and I endorsed the draft, and then I went into like what an endorsement is, and I went into all this kind of stuff, right? And I didn't really need my notes. I remember one time in the hearing, I wanted something from my notes, and I was kind of looking down, and I was kind of like, they were all over the place, and I was like, fuck it, I'm not gonna find it. I just said, well, if you want me to find it after the hearing, I can find it for you, but I can't find it right now. It's just a little bit too much to find on the fly. That's always a good way to handle it. But don't think you have to know everything right then and there, and you have to have everything, they could say something and this and that, and, I can get you more information on that after the hearing. How would you like me to submit that to you via email or into the docket, or how would you like me to get that information to you? It's that easy. There's no way you could know everything about everything that they could possibly ask you at all times. So I don't know how else you could really do it. So going in there and thinking that you're going to have everything for everyone all the time, it's just kind of a losing battle, I think, right?
Severance is part of pretrial procedure. The trial court denied all motions for severance during the pretrial procedure for convenience purposes. Furthermore, according to Rule 14, there must be a request from one of the defendants for the trial court to even consider severance, severing one defendant from the other. If there was a show of the motion submitted by Lee Cromwell requesting severance because Cheryl Blackburn sent a notice to this court that she wasn't going to look at ours because we were 1 day late. And in that document, she admits that she's 9 months late, revealing it, and that we didn't file in a timely manner, but Lee Cromwell did. Even if this shenanigans in the Postal Service, and there is an ongoing investigation with the United States Postal Service Office of Inspector General on this matter, I haven't heard the results of it yet, but this isn't right, what happened. We should, even if it wasn't, say it was a month late, it still should have been considered as an amendment to Lee Cromwell's.
So this is a procedural point. He's saying that they said that it was a day late. And And he's saying, no, it wasn't because of these various factors attached to someone else's filing. Or I don't know exactly what he's talking about, but this is purely just procedural, what they're talking about right now in terms of you only have X amount of days to file something in, and they're saying he missed that, and he's saying, no, we didn't.
Because we can't be severed. You can't sever after the conviction, according to Rule 14.
Remind me again who Lee Cromwell is.
Lee Cromwell he was involved, during this time, he was involved in a vehicular homicide in East Tennessee. The accelerator pedal was frayed on the truck. He put it in reverse, ran over somebody, and killed him. He did what we did. All we did was mail contracts to people that they acquiesced to because they didn't rebut the contract. That's where this comes in at. Now, we didn't file any liens. We took the UCC1 filings and we sent them to the United States Treasury. The United States Treasury filed the liens. They used the IRS to collect the money. The IRS hit me with a frivolous filing twice. I beat it in court. I beat the IRS in court.
So that's what we saw earlier, that there was the UCC3s that were filed on the UCC1s that assigned the UCC1s to the Treasury. We saw that in the appeal document, the first one I was covering with you. I don't know much about all that. I don't really care much about it. He's saying that they weren't liens, but the thing is, there would have already had to have been a lien prior to that point. So I don't know. It just doesn't make sense to me.
And that was based on my ex-wife's bankruptcy. Tennessee said we had no legal basis to do what we did. The federal government agrees with us. The IRS, the tax court, and the Treasury all agree that we had genuine filings. The federal court in Greenville, my ex-wife came and testified against me. She said she had no debt with me. And then she did that at the trial in April of 18. By December of 18, she was filing the $4 million debt in bankruptcy. Okay? And by doing that, Title 11, United States Code, Section 532, subsection A2, says, of the section where bar discharge only where bankrupt has actual knowledge of falsity of the statement or reckless disregard for the truth. She testified that she had no debt with me, took it to bankruptcy, scheduled it, the federal court discharged it. Only provable debts can be discharged in bankruptcy. You cannot take a fraudulent debt into bankruptcy and have it discharged.
So he's saying that he filed a UCC1 on his ex-wife, and she took it to bankruptcy, and they discharged it to the bankruptcy, which proves that it's a real thing, which is interesting, very interesting.
The judgment, I'm going to move on to the judgment orders. Judgment orders, I'm sure you're all familiar with. Judgment orders happen after the judge does the sentencing. And in the Tennessee Constitution, per Article 6, Section 12, it says all writs and other processes shall run in the name of the state of Tennessee and bear test and be signed by the respective clerks. There's allegedly, well, I've seen them now, but there's 42 judgment sheets that haven't been filed. Those judgment sheets is when your time starts. This is when your time starts. The date on this is when you was tried. The Constitution says that they have to be stamped, filed, and signed by the clerk. If you look at the indictment was initialed by someone named KT. It's not signed. Okay? None of the judgment orders were stamped and filed per Rule 60.02 and the Tennessee Constitution, Article 6, Section 12. Since the judgment orders cannot be corrected per rule, the judgment orders are void. See also Rule 12, B-E, or Bravo Echo, and Rule B-2 of the Tennessee Rules of Criminal Procedure. For that matter, the indictment from the grand juries were not signed respectively by the clerks. At the jury trial, I already explained this. According to that, that's Birmingham Title 11 United States Code, Section 533, subsection A2. That's Birmingham Trust National Bank versus Case. Title 11 United States Code, see Section 532, Note 341, Paragraph 15. A bankrupt is just discharged from provable debt if they are scheduled, properly scheduled. Okay? My ex-wife testified in court that she had no debt with me, that's in the transcripts, turned around 9 months later and scheduled this in bankruptcy. Why didn't she do like the public officials did? Go to the state secretary because of the new law that was created because of what we did that year and have him removed because it's for public officials, right? The lien, we didn't, like I said, we didn't lien anybody. And there's 3 federal agencies agreeing that our liens are valid. What I did is I sent it, what we did, was send a contract to the Treasury. The Secretary of the Treasury at the time was Jacob Lew. Here's $204 million in lien securities. These are yours. If you can collect them, you get 35%. You don't think the Treasury is going to want 35% of $200 million? And we had a combined amount of almost $2 billion in lien securities. The federal government has agreed with what we did. In closing, we were picked up on February the 17th, or February the 15th of 2017. I was told there was a warrant. I asked for the warrant. Oh, we'll show it to you when we question you. Never seen a warrant. Took me down, read me the rights, took us all to Nashville, where they said there was an indictment. I've never seen an indictment until I was released and went to Emma Tennett's office and seen the actual case. 2 weeks later, they had us in Blackburn's court, where I challenged a jurisdiction. We all did. You can't proceed until you answer the challenge. She said, these are some serious charges. How do you plead? I said, I don't. Why? Murder's a serious charge. Rape's a serious charge. Child molestation is a serious charge. And you do not want to go to prison for that. So where's the nature and cause? How do you plead? I don't. Well, I'm going to plead for you. You know you can't practice law from the bench. If she's a judge making a plea for me, she's saying she's my counsel, which we never seen. The whole 15 months I was locked up in Davidson County Jail, I never talked to an attorney. Never gave any attorney any power of attorney. They had a trial that lasted 5 days. The judge said, you can come in, but you'll not be allowed to say anything. Where's the Sixth Amendment in that? To this day, Tennessee has yet to put a single piece of paper in my hand saying they had the right to do anything that they did. And they interfered with the obligation of our contract.
Before your time runs out, this is a post-conviction relief petition, and almost everything I've heard has to do with a direct appeal.
post-conviction relief petition. And he's saying almost everything I've heard so far has to do with a direct appeal, meaning it's regards to a lot of what occurred during that time period as regards to that case that should have been handled in an appeals court.
What post-conviction relief are you seeking, and what are you claiming entitles you to post-conviction relief?
See, like, this is what I keep saying to you guys, and this is something that Joey had to kind of drive into my skull. The justices are always thinking about the rules and the procedure. And we have a tendency to always think about the merits and the facts. We really have to get more focused on the procedural aspects if we want our facts and our merits to be looked at. And I know that makes people so angry. It made me so fucking angry for so long. And then I finally was like, fuck it, I'll do it. I don't really see any other option, frankly. So this is just another great example of procedural aspects. It's all procedural, right?
We deserve post-conviction relief. Blackburn's gone. She's retired. We deserve to finally be heard. We've never been heard. If you take someone and you hold them using unlawful force, that's kidnapping. I was sexually assaulted by a guard in Davidson County, and I reported it, and no cop ever came and took my testimony.
All right.
You understand where this is at? We deserve to be heard. We, the people, Article 1, Section 1, have the right to abolish, reform, alter, or abolish the government in any manner we think proper. That's why I say I'm not here pro se.
All right. Thank you, Mr. Hauser.
Thank you very much, and I hope you consider, like I said, I'm only doing this because you guys have never heard that our due process was violated. Never heard it. Now you have, and now we can go to the federal courts and do a 1983. Thank you very much.
Yeah, see, that's the other thing. 1983, right? So he's saying now we're going to go do a 1983. He can't do a 1983. 42, 1983 is civil. It's a civil action for deprivation of rights, right? Every person under color of law, blah, 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 all this stuff, right? The problem is Chapter 21 is all about civil rights, right? Civil rights aren't for the white people. White people don't have civil rights. White people have rights. White people who are, he said that he was a citizen, he basically said he was a citizen of the state of Tennessee. He basically said he was a white man who's a citizen of the state of Tennessee. He didn't say that verbatim. He said, I'm a sovereign in accordance with Article 1, Section 31, which we went to and we saw. That means a white guy who is a citizen of the state of Tennessee. So now he's going to go out, 42 U.S.C. 1981, and he's going to use this, which right before 1983 says, all persons within the jurisdiction of the United States shall have and make the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens. And 42 U.S.C. 1982. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens. And then the very next code after this one is 42 U.S.C. 1983. So he started off by saying that he's a white guy who's a citizen of Tennessee, and then at the end he said, no, I'm actually a released Negro after the Civil War, and I'm going to go to the federal government and try to get relief there because I have civil rights and not actual rights. So he completely contradicted himself. He can't do a 42 U.S.C. 1983. So that's an interesting fact, right?
For y'all's day.
Now, this is the state, I believe, coming up to give a rebuttal on that. This next part.
Good morning, Your Honors. May it please the court. Liz Evan on behalf of the state.
On behalf of the state.
The only issue that's properly before the court today is whether this petition was timely, and it was not. There is no tolling provision that applies statutorily, and as far as due process tolling, it has to be some kind of event that's beyond the petitioner's control. And notably here, Davidson County Criminal Court Local Rule 6 allows for e-filing. He could have walked it over and handed it in the proper time. None of these things were done, and so therefore it simply was untimely, which is a strict jurisdictional bar. And Judge Holloway, you're correct that the vast majority of the allegations in the petition could have or were raised on direct appeal, so they're not even colorable. Potentially he might have an ineffective assistance claim, if he were appointed counsel and that was fleshed out, but that only comes if the petition itself is timely filed, and this was not.
So let's go back. I want to hear that one part again. Hold on.
And handed it in the proper time. None of these things were done, and so therefore it simply was untimely, which is a strict jurisdictional bar.
So she's saying procedurally, just purely being 1 day late, if that's what they're saying, that's what Chris said, that's it. Like, there's nothing else to talk about here, basically.
And Judge Holloway, you're correct that the vast majority of the allegations in the petition could have or were raised on direct appeal.
Could have or were, but Chris already said they weren't, which is it's a big issue.
So they're not even colorable. Potentially he might have an ineffective assistance claim.
Ineffective assistance of counsel.
If he were appointed counsel and that was fleshed out, but that only comes if the petition itself is timely filed, and this was not. I'm not going to belabor the point because I know it's been a long morning, but I'm happy to entertain questions from the panel.
See, I like that. I mean, obviously, we can learn a lot from these people. They're in there all the time, right? So it's like, have a little conversation, a little back and forth. You know what I mean? Like, I wish I had a video of mine that I did at the small claims. I didn't do that. I was just so freaked out about the whole thing, and I was just so nervous. But he had questions and stuff, and I made sure to like really stop and like really answer his questions. But I think as we learn more, and I think as we get more comfortable with this, we're going to start doing things like, does that answer your question? Do you have any other questions? I'm here to entertain any other questions you might have. It's more of a dialogue back and forth, which can be really tough when your emotions are really flared up. But it's one of those things. If we had more people doing this, if we had more people getting hearings, if we had more people doing these kinds of critiques or reviews, we would be able to work towards having this lady's level of just like kind of nonchalance and comfort being in there. There's no other path. It's the only path. There's only one path there. The path is do it a whole bunch, and hopefully other people will do it, and we can all share the information. That's it. To expect to just go in there one shot, one bullet in the chamber, and that's it all the time, it's just tough. So.
We would ask that you affirm.
All right, thank you, General. All right, that completes the morning docket. We'll be in recess till 1:30.
All rise.
Y'all follow YouTube and watch the video. There's 10,000 on the first one.
At the end there, he's talking about the two earlier videos that he has. The one, I forget where it is, and then the other one, which is the Supreme Court one. So there you go, guys. I wanted to do this because this just happened. This was just uploaded several hours ago today. Today is the 11th of November. It was just uploaded to YouTube today. I think they literally had that live. That was a live taping. So again, gosh, I really wish we saw more of this. I really wish I saw more of these kinds of videos. I think the way that he presented himself is just beautiful. I think he did a great job overall. Obviously, I've said the things that I wouldn't have done or I would have done. And it just goes to show you the importance of the procedural aspects, which the 3.0 contract killer course is going to be probably well over half the course is just going to be procedural stuff. The federal rules of civil procedure, rules of evidence, rules of professional conduct, local rules. Just that alone is probably going to be half the course, if not 60 to 70% of the course, just so you guys know. So that's where we're headed. We're going to become masters of procedure, because really all that was said during that whole time was procedural. All this stuff should have been brought up at the appeal, and it wasn't. Procedural. It's a day late. Procedural. That's it. The merits, you guys think, oh, wow, he's really got him, and the merits and all this kind of stuff. It all becomes irrelevant. You could talk for 5 hours. It doesn't mean anything if the procedural aspects aren't there. So I may do more of these if you guys send them to me, if I become aware of more of these kinds of videos. But, crazy screaming and yelling and running around and all this kind of stuff, I'm not going to do reviews on those, because those are awful and they're never going to go anywhere. So with that said, I hope you guys like this. I'll put the links down below. I'll put a link to the docket. I'll put a link to the appeal doc that we were reading at the beginning on Justitia, and I'll put a link to the video that we just watched. Okay, guys? I will see you later. Hope you enjoyed this. Bye-bye.